The last court we need to discuss is the Supreme Court of the United States, which just so happens to be the highest court in the land. The Supreme Court is the highest court in the land, and the proceedings that take place within it are unique as compared to any other type of courtroom you may have seen or heard about. For example, if you look at the picture on the screen, you can see the bench behind which the 9 Supreme Court judges, or as they're more properly referred to as justices, sit and listen to cases. That's 9 justices or judges compared to the single judge you're used to seeing in a criminal courtroom. And that's just one of the many significant differences between the Supreme Court and other courts with which you have some familiarity. So the Supreme Court is the highest court in the land and therefore the head of the U.S. judicial branch. And while there's not a lot of detail in the U.S. Constitution regarding any courts within the federal court system, the Supreme Court is the only one mentioned in the Constitution, which basically says, we, the old dead white guys, want to have a judicial branch and Supreme Court. Future Congress, you set it up, which they did. So the size of the Supreme Court has been and still is determined by Congress. The number of justices, as we've mentioned, is currently 9, but that is not a number set in stone. Back in the 1940s, then President Franklin Roosevelt floated the idea of increasing the size of the court to 12 justices, but obviously that never came to fruition. So the possibility of an expanded court exists. However, as of this moment in time, we are many steps away from seeing that become a reality. Of the 9 justices, one of them is the Chief Justice. The other 8 are known as Associate Justices. And while the Chief does have a few extra powers and responsibilities, he or she only has 1 vote, as do each of the remaining 8 Associate Justices when it comes time to decide a Supreme Court case. Supreme Court justices are chosen by the president when there is an opening. However, before they are official members, they must be approved by a majority of the Senate. Because there are only 9 of these justices in the entire land, and once approved, as you will see, they serve for life, each appointment is very important. After all, there is no guarantee that a president of the United States will get to pick any justices, because in order for there to be an opening, a current justice would have to die or resign during a president's time in office. Then, and only then, does a president of the United States get the very important responsibility of filling a seat on the highest court in the land. And remember, because they serve for life, these justices can have impact on our government, laws, and country long after the president who appointed them has left the White House. The salary for the current Chief Justice is $267,000 a year, while the other Associate Justices make slightly less. But understand, just like the President of the United States, these justices are not in their position for the pursuit of money. They are here to shape the American legal system as well as history. The roughly $250,000 they make in service on the Supreme Court pales in comparison to the millions of dollars they could make if they resigned from the Supreme Court and went to work for a private law firm. Although, for the average American, a $250,000 yearly salary would be no small, tidy sum. As previously mentioned, once appointed and approved, justices serve for life. And oddly enough, there are no qualifications for serving on the Supreme Court. So technically, all of you are currently eligible for service on the Supreme Court. However, all Supreme Court justices, past and present, have been lawyers, and most have been judges in lower courts. Lastly, Supreme Court justices are supposed to be nonpartisan, which means they are not officially aligned with any political party. There are no Republicans or Democrats on the Supreme Court. However, if you look at their voting records, it becomes pretty easy to classify justices as either conservative or liberal. And obviously, Republican presidents tend to pick justices who've shown a history of making rulings that satisfy conservative Republican concerns, whereas a Democratic president would be more inclined to appoint justices who tend to demonstrate decisions viewed as more liberal. Although it's important to note that once appointed, justices are under no obligation to decide cases in a fashion that pleases the president who appointed them. Although justices, like tigers, don't often change their stripes when it comes to their political philosophies. Here you can see the most recent team photo of the Supreme Court. However, it is no longer an accurate reflection of what the Supreme Court currently looks like. In the front row, you can see the bespectacled Ruth Bader Ginsburg, otherwise known as the notorious RBG. Well, she is dead. She died this past November 2020, and President Trump nominated and the Senate approved her replacement, Justice Amy Coney Barrett. So stay tuned in for next year's exciting team picture. While the current court does have some notable members, the only current member that you should familiarize yourself with is the current Chief Justice, who is seated in the middle of the front row, and that's John Roberts. Other notable justices you should be aware of include the first of only two African Americans to serve as justices on the court, and that's Thurgood Marshall, who was appointed in 1967 and served until 1991. Also important to note that before serving on the court as a justice, he won a very important case in the Supreme Court called Brown versus the Board of Education, which led to the desegregation of public schools in the United States. Also important to mention is Sandra Day O'Connor, who was the first female appointed to the court. This glass ceiling, the first female, wasn't broken until 1981, almost 200 years after the Supreme Court was created. That 200-year freeze-out being just another example of our history of not empowering half of our population. But in 1981, Sandra Day O'Connor was appointed by then-President Ronald Reagan, and she became the first of eventually 5 women to have served on the Supreme Court. She no longer serves as she resigned her seat to take care of her ailing husband, but she is still alive. Then we have current Justice Sonia Sotomayor, who was appointed by Barack Obama. Sotomayor is the first Hispanic member of the court. The Supreme Court's biggest power is the power of judicial review, which is their ability to review actions undertaken by the government, in addition to laws passed by local, state, and federal legislative bodies, for the purpose of ensuring those laws or actions don't conflict with our highest set of laws, the United States Constitution. If the Supreme Court rules an action of the government or a law passed by local, state, or federal legislators conflicts with the U.S. Constitution, then that contradictory law is declared unconstitutional and no longer has the force of law. Perhaps more unusually, this power is not mentioned by the U.S. Constitution. Instead, it came about as a result of a case the Supreme Court heard way back in 1803. That case is the case of Marbury versus Madison. In the waning hours of second President John Adams' presidency, he appointed a number of judges who became known as the midnight judges because of their last-minute appointments to various positions in federal courts. Well, many of these judges were choices that would not have been made by then incoming President Thomas Jefferson, as Jefferson and Adams were from different political parties and would have very different ideas on what type of person they'd want to serve as a judge in a federal courtroom. One of the midnight judges was a man by the name of William Marbury, and by the time Adams had left the office of presidency, Marbury still had not received his commission as a judge. So incoming President Thomas Jefferson, then President Thomas Jefferson, ordered his Secretary of State, James Madison, to pump the brakes and deny Marbury his position as a judge because he wasn't a Jefferson guy. Marbury sued, and the case became known as Marbury versus Madison. The Supreme Court heard arguments and decided that Marbury was unfairly denied his position. However, the Supreme Court furthermore stated that they could only rule on whether or not an action or law is unconstitutional or constitutional, and therefore could not force Jefferson to deliver the commission. Everyone nodded in agreement, and thus the Supreme Court gave itself its greatest power, the power of judicial review, which they've exercised ever since. On a side note, William Marbury never did receive his federal commission as a judge, but he did go on to enjoy a very successful career in banking. Supreme Court cases are very different in appearance as compared to those you may be more familiar with. That is mostly because the Supreme Court is basically an appeals court. They do not exist to declare guilt or innocence, but rather they review decisions of lower courts when asked, and review laws to make sure they do not conflict with the Constitution. They do get to choose the cases they hear, and in doing so usually hear somewhere in the neighborhood of between 100 and 200 cases each year. Understand, there are approximately 7,000 people who will ask the court to hear their cases, but less than 200 will have their arguments heard before the very distinguished 9 justices who make up the Supreme Court. Also understand the Supreme Court looks to hear cases of national importance, ones whose outcomes can affect an entire country. For example, are protesters protected from punishment if they burn an American flag? Can states deny same-sex couples the right to get married? Can schools censor student newspapers? While those cases may not be as sexy as whether or not a Heisman Trophy winning NFL Hall of Fame running back brutally murdered his ex-wife and another man, those aforementioned cases involving free speech and equal protection under the law, those outcomes affect all Americans, not just those directly interested in the guilt or innocence of a high-profile murder suspect. In order for a case to be heard in the Supreme Court, 4 of the 9 justices have to agree to hear the case. If they don't agree to hear the case, then the lower court decision stands or remains in place. Once the Supreme Court agrees to hear a case, lawyers from each side prepare a brief, which is basically a persuasive paper that explains each side's arguments in the case. Then the big moment occurs when the lawyers from each side appear before the justices and get to present their oral arguments in person. The cases are only heard 3 days a week, and lawyers are limited to 1 hour to present their cases to the justices. This means that the court usually hears 2 cases per workday. Decisions on the case are not made immediately. Justices meet every Friday to discuss all cases yet to be decided. In order for a decision to be reached, 6 justices must be present. And regardless of the number present, 5 justices must agree to reach a majority and thus a decision. In reaching their decision, each justice has 1 vote, and they can choose to abstain or not vote. In making their decision public, the Chief Justice picks 1 of the 9 justices to write what is known as a majority decision, which explains the reasons behind the Supreme Court's decision. This is very important because the wording of the decision used by the justices to explain the reasons behind their decision can be used by future lawyers and future judges in attempts to settle court cases that may arise in the future that have similar legal issues. So the majority decisions have consequences that reach farther and touch more than just the people who brought the case to the Supreme Court. It is also possible that a justice agrees with the majority decision. However, their reason for doing so is slightly different from that of the other justices. If that is the case, that justice is welcome to write their own opinion called a concurring opinion, which explains their position. To concur means to agree. So they agree with the majority, but for slightly different reasons. Concurring opinions are not as significant as majority opinions, but they too could be used by future lawyers and judges to support a position in other related cases. Lastly, it is quite possible that there are justices who disagree with the majority decision. They too are welcome to explain why they feel the court has ruled incorrectly by writing a dissenting opinion. The word dissent means to disagree. Dissenting opinions do not change the ruling of the court, but they do have some significance. But since they are the minority view of the court, they don't carry nearly as much weight as the majority or concurring opinions. Regardless of whether or not you agree or disagree with the decision of the Supreme Court, their ruling is final, as they are the highest court in the land.